defense and duress, two crucial criminal law defenses that often decide the outcome of a case. We compare Nigeria and UK law, look at landmark cases, and real life examples so you can clearly understand when these defenses apply, their limits, and how courts analyze them. By the end of this, you will be able to identify elements of self-defense and duress, apply them to any given situation, as well as compare Nigeria and UK approaches. Let's start with self-defense. What is self-defense in criminal law? Self-defense is a justificatory defense that allows a person to use reasonable force to protect themselves, another person, property, and in some cases, to prevent a crime. Illustration. A shop owner seeing an intruder break in physically restrains the intruder until police arrive. If the force is reasonable, the law protects the shop owner. However, if the force is excessive, the law frowns at it. Now, what is the legal basis in the UK? In the UK, Common Law Principles, Section 3, Criminal Law Act 1967, allows reasonable force to prevent crime. See the case of Regina against Palmer, 1971. This expressly states that a person may act instinctively in a perceived threat. Example, a man sees someone attacking his friend and punches the attacker. He honestly believes it's necessary to protect his friend. This would likely satisfy the UK's subjective and objective tests. Now, what is the legal basis in Nigeria? In Nigeria, this is covered by Criminal Code, Southern Nigeria, and Penal Code, Northern Nigeria. Note particularly that sections 286 to 288 of the Criminal Code in Nigeria cover defense of person and property. Example, a Lagos resident sees someone attempting to steal their car. Using reasonable force, they prevent the theft. Under Nigerian law, this is likely a successful self-defense claim. Now, what are the elements of self-defense? A. Imminent threat. Harm must be immediate. You cannot use force against someone who insulted you yesterday. The threat is no longer immediate. B. Necessity. Force must be necessary. Escaping danger without fighting may be required before using force. C. Proportionality. This means response must be reasonable. Responding to a slap with a deadly force, such as using a weapon, fails the proportionality test. Now, what is reasonableness assessment? Reasonableness assessment is classed into subjective. Did the defendant honestly believe force was necessary? And objective, was the force reasonable under the circumstance? See the case of Regina against Owino, 1996. This case uses combined subjective and objective approach. For example, a terrified person hits a stranger thinking they are being attacked. If the belief was honest, but force like slightly excessive. Cost may reduce liability but not entirely reject defense. Now, the concept of excessive force. Excessive force can be better be looked at in the case of Regina against Clegg 1995, in which a soldier shot a car after threat had passed. Defense failed for excessive force. In Nigeria, excessive retaliation invalidates self-defense. For example, if a householder strikes an intruder, wants to subdue them, if they then continue hitting after the threat stops, they may lose the defense. This is because of the use of excessive force. Nevertheless, some legal scholars argue that laws should consider trauma and panic, not just measured force. What is self-defense for property? In the case of property, force must be reasonable. However, deadly force for property alone is usually not justified. For example, shooting a thief stealing a phone is likely excessive, but restraining them is lawful. Again, if someone throws rocks to stop a burglar, court may evaluate proportionality. Now let's turn to duress. What exactly is duress? Duress is pressure or threats used to force someone to act against their free will. Duress is an excuse and not a justification. Duress is committed under threat of death or serious harm. What are the types of duress? Duress by threats, that is, threats from another person, applicable in Nigeria and the UK. Here, a defendant commits crime due to immediate threats of death or serious injury. See the case of Regina against Hassan, 2005. What are the elements of duress in the UK? 1. Threat of death or serious injury. 2. Immediate or imminent threat, and a reasonable person would act similarly. And there is no safe escape. However, there must be no voluntary association with criminals. Again, if a person is forced to steal under threat of immediate harm, if safe escape was available, duress automatically fails. It is worthy to note that reasonable person standard may disadvantage vulnerable individuals such as children or disabled persons. Duress of circumstances. This arises from external events that creates pressure equivalent to threat. See the case of Regina against Conway, 1989, in which the defendant was speeding to avoid serious harm. Nigeria does not formally recognize duress of circumstances. Example, if a driver exceeds speed limits to escape flood water, this is duress of circumstances. Duress and murder. Duress is not available for murder or attempted murder. See the case of Regina against Howe, 1987. You cannot kill someone under threats and claim duress. Now, self-defense versus duress. Self-defense protects you from attacker. Duress excuses coerced theft. In conclusion, self-defense, justification, acquitted if elements are met. Duress is excused. Liability will be mitigated in some offenses. See you in the next video.